I'm going to continue with my theme of leveling the playing field. And I want to elaborate on the last comment that I made after Ms. Yang testified in response to my question. My experience over 30 plus years of being a litigator, most of which, by the way, Ms. Olson, was on the defense side, meaning I represented the companies or people who were being sued by somebody represented by a trial lawyer. And for anybody who doesn't know, trial lawyer is commonly used to refer to lawyers who represent plaintiffs. But in my experience, far from being the villains, almost every trial lawyer I encountered was the only hope for a plaintiff who was unsophisticated, didn't understand the law, and had no hope of pursuing a legal claim without the expertise of his or her lawyer. Our legal system is dependent on having lawyers who will help individuals who are unsophisticated in the law or who do not know their legal rights. So for instance, when my colleague on the other side of the aisle, Mr. Johnson, was talking about retaliation being forbidden and Ms. Olson was engaging in the dialogue with him, the only way an employee would be able to pursue a claim of retaliation is with the benefit of a trial lawyer to help him or her. So, with that said, I'm going to ask Ms. Roe Finkbeiner, in your testimony, you shared an interesting perspective, and we're going to shift gears a little bit to class actions. As you may have ascertained, I like to get into the weeds on this legal stuff. But I was drawn to your testimony on why it's important to amend the Equal Pay Act to change the class action to be an opt-out standard, similar to the standard under Title VII and under Rule 23 of the Federal Rules of Civil Procedure. From the perspective of the women that you've engaged with, why is it important for them to be able to band together in such actions? And maybe you could just explain that a little bit for those who aren't familiar with the opt-out standard.
Well, we need to remember again who is being impacted the most by unfair pay, to your question, which is low-income women. The lower your income, and 3/4 of minimum wage workers are women, the more significant you're going to be impacted by wage gaps. And so for lower wage women workers, automatic inclusion in class action lawsuits is vitally important because it is also in those job positions that you are most vulnerable to retaliation. The moms of America that we hear from every day are telling us their story about their unfair pay. They're telling each other their story about unfair pay, but they are absolutely afraid to step forward and talk to their employer or to take action, or much less afford an attorney. And this is very important because if we don't have this inclusion, if we can't stand together, then women have to stand up by themselves and say, I am experiencing unfair pay. And let me tell you, that does not go well. We hear from the moms of America what happens when they stand up and they lose their jobs, or they're told, you know, it's this or the highway. And so we hear that again and again and again, and what that says is that the current law is not sufficient. What's happening right now is not sufficient. We have right now experiences where we have moms with equal resumes on pieces of paper, not actually in person, getting hired 80% less of the time than non-moms. So current law is not sufficient. We need to be able to band together. We need to be able to protect women from retaliation, and the way to protect women from retaliation is to have an inclusive group rising together, and that's absolutely needed, as shown by the horrifyingly horrible pay gap data that we see right now today.
And just to be perfectly clear, opt-out would mean that they would be included in the class unless they chose to opt out if they were discriminated against. Is that correct?
I want to defer to Ms. Yang, who is an attorney.
Okay, and I'm going to ask Ms. Yang a question anyway, so she can address it in response to this. Prior to your time at the EEOC, you spent 15 years litigating equal pay and other discrimination cases on behalf of employees. And litigation is obviously very expensive, especially with the threat of the prevailing party recovering attorney's fees. And that often scares off aggrieved workers. Would you agree with that?
Yes.
Okay. Could you discuss, please, how, in your experience, employers used the prevailing party doctrine to extort or deter aggrieved workers' claims, and how the Paycheck Fairness Act levels the playing field on that issue? And at the same time, perhaps you could address the question.
And before you answer, Ms. Yang, the time has expired and the hour is late, so I'm going to ask you to submit that response to the record because we still have